Brantley?
Hey, Todd.
Yeah, just let you know, Cherie's been having some technical issues like the last half an hour with the video on her iPad and phone. Would you have any problem with her calling in?
No, I wouldn't.
Okay. I guess she's going to be sworn in, though.
You'd have to have a notary if she's just going to be calling in. You'd have to have somebody to swear in.
Okay. Try to troubleshoot with her for one more second here.
Okay.
It out. Actually, I think she's going to be able to get on there by video in the waiting area.
Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. I was monitoring communications there, so I stayed off the record for a moment while you all got connected, but someone connected thereafter, so I'm going to assume that that might be Ms. Woods on iPad 8.
Yes.
Okay. All right, so we have a matter at 2 o'clock, Wharton v. Woods. Can I get counsel's appearance for Plaintiff Wharton?
Absolutely, Your Honor. Brantley Oakey on behalf of the plaintiff, Charles Wharton.
Okay, and for defendant Ms. Woods?
Yes, Todd Rich for defendant Woods.
Okay, and Ms. Woods is present as well. And we do have Madam Court Reporter, so if everyone can try to speak slowly and clearly as well. And ma'am, if you start to wave feverishly, we'll know it's probably because somebody's microphone went out, and we'll try to keep one eye on you as well. Okay, Mr. Oakey, this is your motion to have the court determine entitlement to fees. I believe it's just entitlement and not amount. Is that correct?
That's correct, Your Honor. And speaking with Mr. Rich, he agreed that we would proceed just on entitlements so that my client wouldn't have to incur any kind of expert fees dealing with reasonableness when it was unclear whether or not we would have entitlements. So I chose to bifurcate this. We're just seeking entitlement, and if necessary, we'll have a return hearing as to reasonableness.
Okay. All right, very well. I have reviewed the file, and both sides did, to some extent, brief what their positions are. I have at least some idea of the points of disagreement, but we'll invite plaintiff to go ahead and proceed on setting forth their motion, and we'll see where that takes us. Before I do that, Mr. Rich, is there anything that you would say at the outset, any narrowing of the issues or anything that we can ask from you to just sort of make sure that we stay focused on the points that you contest?
Sure. I was trying to think of the best way efficiently to do this, and I believe that my second argument would probably be the best to hear first, because it's more just legal argument about whether the fees incurred have even been execution of a judgment. And
Okay,
if you rule that it's not, then we don't really have to hear any testimony or spend extra time with argument one.
okay. And so the defense suggests that that's a threshold issue, whether this proceeding has in fact been an execution of a judgment such that Mr. Oki is properly citing a statutory authority for fees. If I disagree with Mr. Oki and adopt the defense position, then Mr. Rich, you're suggesting that would foreclose the need to have any further hearing.
Right.
Mr. Oki, is in terms of a procedural overview, do you agree that that's an accurate overview?
I do. I think that would be a great way to proceed, Your Honor.
Okay, let's focus on that issue first and see where that takes us.
Great. So can I ask the court to allow me to share my screen, if that's not already done? Let me see.
You should be able to. Do you have a green share screen button?
I do, and I'm pulling this up now.
It's like asking to approach in the new tech era. Always good to ask permission first.
Very good. Thank you, Your Honor. So I've got 3 cases on this that we can look at. The first one is Flava Works, Inc. versus A4A, I guess Resau, Inc. This is a United States District Court of the Southern District. So it is persuasive, not binding, but I would suggest that it's very persuasive. And in this case, the court deals directly with this issue of how broad is the 57.115 statute. And both sides, of course, brief the matter, and then the court offers analysis. So I'm going to skip to that section of it. And the party that was opposing the motion for fees cited to 2 cases. One of them is Paz v. Hernandez, and the other one was Ocean Cruise Lines versus Greenidge. And in fact, Mr. Rich referenced those in a previous response to a previous version of the motion. Paz essentially says that you cannot get fees under 57.115 for a motion for garnishment because that is a separate statute. It's a separate supplementary action, and any fees related thereto would be governed under the garnishment statute, not 57.115. Ocean Cruises dealt with a supplementary action for a fraudulent transfer. So these were the cases that the party opposing the motion provided to the court to suggest that there needed to be a narrow reading of the statute in execution or in direct connection of execution of a judgment. And the court notes that the above decisions, I'm going to read this, limit an award of post-judgment attorney's fees to matters that are directly connected to a judgment's execution and exclude collateral proceedings, even though those collateral proceedings may relate to the creditor's collection efforts on that judgment. In Paz, where the collateral proceeding was based upon an independent statute, the court looked to that statute to determine the authority for attorney's fees. Likewise, in Ocean Cruise Lines, Inc., an independent proceeding was necessary to determine whether the judgment could be executed against a third-party recipient of the judgment debtor's assets. In this case, unlike Paz and Ocean Cruise, there is no collateral proceeding that has commenced, so the defendants could execute on their judgment. Therefore, there is no independent statute needed to determine defendants' entitlement to post-judgment attorney's fees. Here, defendants are only trying to obtain their fees and costs for their discovery and collection efforts that occurred in direct connection to the judgment's execution. This is entirely permissible. So that's case number 1 that I will share with the court. The second one, and I note that in this case, the federal district court cites to Vic v. Vic, and I've got that here as well. Very short case. The only portion of it that is on point, it begins right here. It says, we also agree that the former wife is entitled to post-judgment attorney's fees and receiver's fees and costs until the judgment is fully satisfied, and then references 57 57.115, suggesting that any of those fees or receiver's fees and costs that are incurred up until it's satisfied would fall within the parameters of being in direct connection of executing on a judgment. The last one that I will share is Weber v. Agostino. This is a fourth DCA case, and I don't think I gave you the Vic, but let me just jump back to that. That's a fifth DCA case from 2008. So Weber v. D'Agostino is 2018 fourth DCA. And in this case, the argument that's made by the party opposing attorney's fees is the exact argument that's being advanced by the defendant here, that it's limited, that it's a narrow scope, the idea of this execution of judgment. And actually, let me jump back and give you a little background on this case, because that is important here. This was a case where the court entered a final judgment in 2014. Then the borrower filed a suggestion of bankruptcy in 2015. That was dismissed. Then in 2015, the borrower moved for relief from judgment. So in other words, there was a lot of litigation after the judgment was entered to either set aside the judgment or have it discharged in bankruptcy. And the question is any of that considered an execution of judgment? And the court says that in referencing 57.115, the court may award against a judgment debtor reasonable costs and attorney's fees incurred thereafter by a judgment creditor in connection with execution of the judgment. The continued litigation over the final judgment in state courts and in bankruptcy court were in connection with execution on the judgment. Okay, so the three cases that I've given you show that discovery and collection efforts that do not fall under a collateral action fall within the parameters of 57.115, meaning that we can recover fees and costs for those. They show that continued litigation post-judgment, that a party can receive attorney's fees and costs for that. So the courts have taken a broad interpretation of what that means to be in direct connection with execution of the judgment. I'm not aware of any ruling that suggests that it's only the process of actually submitting a writ of execution and having that executed by the clerk, or taking that to the sheriff's department or something very narrow like that. All of the rulings on this suggest that it's broad. The exception or the limit to that is when you're moving for garnishment or you're moving under proceeding supplementary, and there's a separate statute. It's a collateral action with a separate statute that would then govern whether or not you can receive fees. So in this case, what we're asking for certainly falls within what can be awarded according to the case law that I've just provided. And essentially what that is are the efforts that the costs with recording the foreign judgment, the efforts to draft discovery, serve discovery, communicate with the defendant, move to compel, move for an order to show cause. These are all things that are directly connected and are necessary to try to execute on the judgment. And we've stopped short, the point in the case procedurally where we've stopped the request is that point where we moved for garnishment. So we're not asking for anything beginning with the motion for garnishment. It's what was done before that it relates to discovery and trying to execute on the judgment. And so I believe that based on the case law, that clearly falls within 57.115. I'll leave it at that. Thank you, Your Honor.
Okay, Mr. Rich, your response to that portion of the argument today.
Yes, Your Honor. So just to start off, I mean, I will admit that some of the case law can be a little bit confusing when I read it, and it is, to me, clearer now after rereading these cases and the statute. But to start off, as far as attorney's fees, case law says that statutory authorization for attorney's fees is to be strictly construed. So we're starting off on that basis where we have to read the statutes strictly on their language. So when we look at 57.115, it specifically is giving that discretion to award fees in connection with execution on a judgment. So we have to strictly construe it. And upon just reading it on its face, execution on a judgment is a specific type of enforcement of a judgment. And just right off the bat, this case does not involve any type of writ of execution being issued. Or can take judicial notice of the case. Not a single writ of execution is issued. I've had them issued in dozens of cases when I want to levy on property. No efforts to levy in this type of case. No proceeding supplementary where you need a writ of execution to actually have proceeding supplementary granted. So on its face, no execution on a judgment. Now, when we look at the case law, so I had cited one case that just again separated that execution is different and is a different form of final process used to enforce a judgment. It's the Bershon v. National Union Fire case. It's just a line or two just saying that essentially it's a way to enforce a judgment. And Mr. Oki did mention the case that I am primarily relying on. It's the Paz v. Hernandez case, where a judgment creditor was unable to collect upon his judgment and serve writ of garnishment. And the judgment was paid off, like the instant case, and they moved for fees under 57.115. And the debtor argued that the creditor never executed upon a judgment since he proceeded under the garnishment statute, so that they should be denied their fees. The third DCA agreed, and they said they would not accept the argument by the judgment creditor that garnishment is merely another form of execution. So, I mean, again, reading it strictly, it has to be incurred, one second, in connection with execution of judgment. This case is supporting that. It's essentially saying that they never executed upon a judgment in that case. And then I also cited from the Southern District of Florida, the bankruptcy case called Petty. And I believe, again, this just supports the argument. They're saying that they had not shown that all of their legal activities fall into the relatively narrow category of fees incurred in connection with execution on a judgment. Now, I did cite, I thought I had to cite this because it apparently is a distinguishing case, the Flava Works case that Mr. Oki just cited. And at first I did think that it somewhat distinguished our cases, but after rereading it, I don't think it actually says anything different at all. In Flava Works, it discusses the Paz case. And what they say is the above decisions limit an award of post-judgment attorney's fees to matters that are directly connected to a judgment execution and exclude collateral proceedings. After rereading that, I don't think that case hurts us. And I'd like to add that the Flava Works case actually did involve a writ of execution. And I should have pointed that out in my response, but there was a writ of execution issued in that case, unlike our case. So that would make sense that they're saying it has to be directly connected to a judgment execution. And then Mr. Oki just discussed the other case, the D'Agostino case. And while it's a little bit unclear in there whether it says a writ of execution was issued, I took a quick look at it. It seems like they levied shares of stock, which requires a writ of execution. So I don't think that case hurts us. And I would argue let's look at the statute the way it's stated and what the case law says, and they never executed on a judgment. Thank you.
Okay, give me just 1 second. I'm putting 57.115 in front of myself. Okay. I think I'll put this question to Mr. Rich, because I'm familiar with, certainly familiar with the requirement that the statute be construed strictly and so forth. What I guess I'm not understanding is, if I read this statute narrowly as the defense prefers I do, and I'm going to put the same question to you next, Mr. Oki, but if I read it as the defense suggests, then we have a whole statute section that is dedicated to awarding fees for execution on judgments, and writ of execution, in my experience, which it may not be as vast as yours, but in my experience, a writ of execution is pretty perfunctory. It's not a fee-heavy, labor-heavy process. And I'm sitting here wondering, why did the legislature set up an entire statute to award fees for such a narrow and usually unimpressive aspect of obtaining and collecting upon judgments? There's so much more out there that's meaty. And so I don't know if you have a sense of that. I guess I might be asking for the statutory history, but if it means what you suggest, Mr. Rich, why does that statute make sense? And then there is no correlating statute to provide for fees on any of the other myriad procedures that somebody might have to employ here. Why did the legislature single out writ of execution?
Sure. Well, again, I can't speak to the legislative history, but when they're saying, this is the way I look at it, when saying in connection with execution on a judgment, I do feel that it could encompass significant fees, because it's not just the actual issuance of the writ of execution, but then there's the whole process of levying on the property, someone potentially fighting the levy, foreclosure sale before the sheriff. There's a stock, again, there's a separate one for being supplementary where there's a separate fee granted for that. But yeah, I could see significant fees being covered by it, but I do not know the legislative history on it.
Okay.
I just know the language.
And so that may be helpful. So there's at least some process that goes with execution. My experience in county court and not having practiced in civil prior to that is, I don't know that the word execution has been uttered more than once or twice in all the years. And I've had an exclusively civil docket now for quite a while. I spend tons of time on garnishments, tons of time on post-collection procedures, but execution is just insignificant. So that's why it seems a bit odd to me that there would be a statute dedicated to that, singling that out as something for which fees could be recovered, but then not including fees for any of the other post-judgment proceedings that someone might have to employ to collect.
Okay, can I add one more thing to that?
Sure.
So, I mean, I can see that viewpoint. I would still rely on pause, because pause is, I would say, supporting my argument that, I mean, garnishment you would think is collecting a judgment. To me, that just, collecting a judgment is pretty broad. So you would think garnishment would have been included if the statute is meant to cover everything. But they're just saying, no, you did not execute on a judgment, garnishment separate. That's just how I view it.
Okay. And thank you for that, Mr. Rich. Mr. Oki, let me give you a chance to try to respond to that.
Perfect. In direct response to your question, I would say that I do not think that the legislature would have a statute for that very narrow process of executing. I would additionally say that it doesn't make sense for that statute to reference a judgment debtor being evasive if all you're talking about is the process of executing. I mean, that's a simple, you get a writ of execution, you do the paperwork for the sheriff's office, maybe that's an hour worth of attorney's fees, whatever. They go and they take the piece of property. I don't see it doesn't make any sense to me that a judgment debtor could be evasive in that very narrow process of just executing on property. I think that it's meant to be taken more broadly, just as the courts that in the cases that I've referenced for you have taken it. So for instance, in that the Flava Works case, it specifically says that discovery and collection efforts are part of that execution that's referenced in 57.115. And that makes a lot more sense to me, because judgment debtors can certainly be evasive in collection efforts and can be evasive in discovery. And so I think that the broader meaning is what the legislature intended. And it's certainly, from what I've seen in doing the research, what the district courts of appeals have applied. With regard to the pause case, I completely agree with Mr. Rich that holding is that writs of garnishment are not part of execution under 57.115, and accordingly we have not asked for that. And I think that the reason for that is very clear, and that is there's an entirely separate statute for a writ of garnishment. And so if the legislature had intended there to be attorney's fees for that, it would have fallen within that separate statute. But anything that does not have its own separate statute, this is essentially what the Flava Works court is saying. If there's not a separate statute, if there's not a collateral proceeding that would hold or regulate the activity, then it would fall as just the collection effort or fall within the 57.115. So we're not asking for anything that has a separate statute, that is a collateral action. We're just asking for the discovery and the efforts that we had to make to get the discovery, to get a knowledge of the defendant's assets so we could attempt to execute. Thank you, Your Honor.
It seems interesting that there's not a bit more case law on this, because I'm understanding the arguments of both sides. Obviously a big swing between best case and worst case scenario on these two interpretations. There's a whole field that's just collection on judgments. So that's why but the word, if the legislature had meant fees on collection, they could easily have just said collection. They used execution, which is really, I think it's perhaps that choice of word that gives rise to the ambiguity. Is Mr. Oakey's saying, well, it's broader than that. Mr. Rich is saying it's only that. What I struggle with, Mr. Rich, is that it just doesn't seem to make sense. And Mr. Oakey makes a good point with regard to the subsection 2. Execution is, forgive the phrase, but execution is not, of all the various procedures that are available for post-judgment collection, it's really sort of one of the less often used and certainly the least likely to give rise to fees. Part of what I'm considering too is that, whether you can get fees on the original action, you've got to have either a contract or a statute. But once you already have your judgment and you're having to engage in extensive labor to simply collect on what's already been judicially ordered, it makes sense to me that there will be a statute that would say this is one of the areas in which fees can be obtained. But to say that, but then construe it to only be execution, Mr. Oakey's suggestion that, well, the reason those other matters such as garnishment have been carved out is they have their own statute. But neither argument is without some weaker points. I think it's imperfect. We come across imperfect statutes all the time, and this may be one.
Could I address?
Sure.
I just wanted to address that one point that Mr. Oakey had raised about the other subsection about attempting to avoid or evade the payment of the judgment, I don't actually find that I find that to make sense, because it's not actually saying attempt to avoid or evade the payment of the judgment during the execution process. It's talking about in general. So I guess just for example, let's say a debtor starts moving all of his assets and avoids depositions, and then all of a sudden the creditor finds a piece of real estate he wants to execute upon. So he does it, and then he moves for fees, and he says, well, hey, I had to execute because he was trying to avoid or evade payment. That's how I view the statute. It's not limited to execution. That's just my opinion.
Well, but that sort of undermines your earlier argument, I think. And if that were the case, my fear might be that everything you just described would actually be excluded by this. It would only be the attorney's act of the actual execution, and all of the labor involved in chasing the person down and identifying the piece of property and so on and so forth would be excluded. And right. it seems, in looking at what the public policy likely is behind this, it makes sense to me that they would say, look, once the judgment's entered and you have not paid it, then reasonable fees and costs in connection with collection on that is the better word, but execution are recoverable, and then the court is to look at these things. I just ultimately, I think construing it the way the defense invites me to construe it, while I do understand the mandate to construe it as narrowly as possible, I think it eviscerates it from having any real meaning. It doesn't make sense to have this statute and all the power really that comes with it to address a fairly rare and extremely narrow paperwork maneuver that doesn't bring with it a whole lot of fees. Now, everything outside of that, filing, motion for writ of execution might, but if I read this your way, none of that would be recoverable, even if this were just execution. Right.
It may have been poorly worded, and just my argument would have to be, again, strict construing it, but I hear what you're saying.
Yeah, it strips it of meaning if I go that narrow, is my concern. And the other thing that in looking at the case law, it appears that there is better support really for Mr. Oakey's position. If Mr. Oakey were incorrect in seeking fees for his post-judgment collection efforts, if he were wrong on that, then I think there would be very strong case law that would make it abundantly clear. It's a big enough question that would come up often enough. And that's why I'm saying, if there's no better case law than what we have, and the case law does seem to allow for this, then I'm inclined to find that the 57115 will permit pursuit of these collection fees. Now, it appears that collection procedures that have their own statutes, such as garnishment, have been carved out by the case law, and I'm certainly fine with that. I think in this particular case, that's probably moot. If I recall, there isn't a garnishment. No, that's not correct. There is a garnishment, right? There was a garnishment of Ms. Wood's business.
There is a garnishment, and ultimately that's what led to the parties reaching a settlement, but I'm not asking for anything related to the garnishment in the motion.
Right, okay. Well, then, with regard then to this threshold issue, I'm going to find that 57115 does potentially apply to this type of scenario. I think there may be more that I have to hear before I actually find entitlement, but had I gone the other way, I would have foreclosed the rest of the hearing. And unfortunately, Mr. Rich, I just don't quite find sufficient support with that for that interpretation. So I'll let us proceed further as to whether entitlement is deserved here, but it does appear that the statute, at least as a threshold, provides for these sorts of fees.
Thank you, Your Honor. So in proceeding then, we've set this for an evidentiary hearing so that evidence can be presented as to whether or not or to what degree the defendant attempted to evade the collection process. So with the court's permission, I would begin by offering my own testimony.
Okay, let me do this. Anyone who's going to testify, if you want to raise your right hand, I'll get everybody sworn at once. Is Ms. Woods going to testify? Okay. And Ms. Woods, I'll need you to unmute so I can get your answer to this question when I swear you.
Okay.
Okay. All right. If you'll raise your right hand. Do you both solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I
Yes.
do.
Okay. All right. Both have been sworn. Mr. Oki, you may proceed.
Thank you, Your Honor. This is a case that began in January of 2017 by recording a foreign judgment. The foreign judgment was sent to the debtor by certified mail. That's reflected in the docket. I would note and ask the court to take judicial notice of item number 9 in the docket that reflects that the certified mailing from the clerk was returned unclaimed. In March, on March 3rd, 2017, my office drafted interrogatories and requests for production. Those were sent to the defendant as well by certified mail. Those were also unclaimed. In April, my office attempted to set a deposition of the defendant, and we attempted to serve through the Collier County Sheriff's Office a notice of the deposition on the defendant. That notice of deposition and that attempt of service failed, and the return shows that it was unserved, and I would ask the court to look at and take judicial notice of docket number, item number 17.
Let me interrupt you because I'm using, we have a judicial software that overlays over Showcase, but I do not have docket numbers. They're working on that for a subsequent version, but I have filing dates. So if you could, and this is the second thing you've referenced, can you give me both filing dates?
Yes, I can. So the filing date that for the first one I referenced was March 13th, 2017.
Okay. And that was the unclaimed
Certified mailing.
I tried a shortcut that didn't work. Give me just one more moment here.
Brantley, what was the other docket number?
I probably should have just shared the screen again. Maybe that would have been.
I have it, and I have, so I have the March 13, which is unsigned. Okay, and the second thing you were referencing?
Second thing is the return of service, which is filed May 2nd, 2017. And
I'd object to the introduction of that document.
Okay.
On grounds of hearsay, and the process server is not here to testify. Yeah, I definitely object to that.
Okay. Mr. Oki?
well, there's a request for judicial notice in the court file that was never objected to, and returns of service from the process servers are public record that are covered by the hearsay exception.
And I would respond, I have seen case on this, not every portion is admissible, and the comments by the process server, that is clear hearsay. I'm unable to cross-examine him as well.
Okay. Well, let me do this. I'm going to sustain the objection at this juncture, but it's possible that Mr. Oki, you'll lay some more foundation. I can take judicial notice of the court file, but I do think that Mr. Rich's objection is well taken. If I'm being asked to take those comments for the truth of the matter asserted therein, I think we start to go beyond what the judicial notice of the court file would let me actually take in and consider here. I can certainly take judicial notice of the fact that service, this was filed when it was filed, that it reflects service or not service, but the comments I think would be going outside of what I can really look at on a judicial notice.
Okay. All right, so then on the CCSO was unable to serve the defendant. On August 17th, my office filed a motion to compel. We had a hearing. The court entered an order to compel the discovery that had been outstanding since March. On August 24th, we were finally successful in serving the defendant. We did not receive discovery. I would say also throughout this time, I made multiple phone calls to the defendant's place of business. I learned that she was a realtor at Premier Plus. I left multiple voicemails at her office. None of those were returned. We also sent out multiple letters. None of those were responded to. We then moved for an order to show cause, and the court issued an order to show cause on, I believe that was December 19th. Let me just double check that.
I see that.
And then it was shortly thereafter, when the show cause hearing was set, that the defendant retained counsel. I will not offer any further argument, as I guess we're just in the evidentiary phase. So I will close my testimony there. I'm reserved to make final argument.
Mr. Rich, do you have any cross-examination for Mr. Oki?
One moment here. Yes, Mr. Oki. I could just ask you a few brief questions.
Sure.
Would you admit that there's no evidence Ms. Woods actually received the discovery at first?
No, I would not admit that.
But you said that oh, go ahead.
I would say that Ms. Woods was doing everything she could to avoid receiving the paperwork, receiving the discovery, receiving notice of the lawsuit. I would say that she was purposely trying to avoid having to address the foreign judgment that we were attempting to collect on.
What if I told you that she did not receive it because you said it was unclaimed? Would that surprise you?
It would not surprise me, because in my experience, when someone is trying to evade or delay, they do not claim their certified mailings. That's part of the attempts to evade the service and evade receiving the documents. Of course, the post office is going to leave notes telling them to call us back. There's the package here waiting for you. Come pick it up. So a person's given opportunity to pick that up and respond, and Ms. Woods did not do that.
But you're assuming that she's acting like the other debtors you've dealt with, correct?
I'm assuming that the protocol for the post office was followed, and that she received notice that they attempted delivery. I'm assuming that, yes.
And no further question.
Okay. Mr. Oki, any other testimony or evidence? Any other witnesses?
No, Your Honor.
Okay. All right. Mr. Rich, do you wish to put on any testimony or evidence?
Yes, Your Honor. And before I have Ms. Woods testify, I was just wondering if I could give a brief overview of what I plan to have her testify to.
Okay.
It's like an intro. So essentially, we're on my argument 1, where we're arguing that these fees are discretionary and that the facts do not justify them in this particular case. Essentially, the court should consider whether the debtor had attempted to avoid or evade payment of the judgment. And we plan to show that she was not attempting to avoid or evade paying the judgment, and she's essentially just struggling financially and didn't have the ability to pay this debt at the time. This is a case where she did pay off the judgment, which can be rare, but she did pay it off, and with a payment plan. And we plan to show that while some discovery deadlines were missed, this discovery is very limited, and there's an explanation for it. And with that being said, if I could have her testify, Ms. Woods.
Okay.
Ms. Woods, if you could please state your name for the record.
Cherry Woods.
Thank you. And how long have you lived in Florida?
Since 2007, full-time. I owned a place prior to that, but I didn't live here full-time.
2007. And do you recall a Tennessee judgment against you by the plaintiff?
Yes.
And Your Honor, I did file some exhibits in the record, just about 8 of them. It should be the last docket entry. I don't know, and it starts on page 2, the exhibit I was going to show her.
Okay.
And Brantley, so this is going to be exhibit 1. So Ms. Woods, if you could just take a look at exhibit 1. Just let me know when you have that up.
Is that the one that starts out State of Tennessee, Franklin County?
Yes.
Okay.
Okay, and what does that document appear to be?
I guess it's the filing of the suit, of the original action.
Page, let's go to the second page of that exhibit. If you could read the title of that document.
Order dismissing appeal and granting judgment.
Okay. And what is the date listed on there right above to the right?
August 29th, 2016.
Okay. So at the time of August 29th, 2016, were you living in Florida?
Yes.
Okay. Your Honor, if I could ask the court just to take judicial notice of that document. It is in the court file and it's a public record.
Any objection?
No, Your Honor.
All right. Let me make sure that I'm clear because I was looking at 2 different things, Mr. Rich. You have your client talking about exhibit 1 of the exhibits that you filed, that State of Tennessee, Franklin County. Is it just the first page or is it several pages?
It's several pages.
Okay. The order dismissing appeal and granting judgment. And then there's an affidavit. Just want to make sure how much I'm pulling in here together. Is the affidavit of Brantley Oki also part of that? That looks like the last page of exhibit 1.
We don't need to include that if it makes it easier.
Okay. Okay, well, I'll admit exhibit 1 and I think I'm caught back up. Go ahead.
Okay. And then I'd also like to show Exhibit 5, which it's on page 48, Your Honor, of the document that I filed for easy reference. And Cherie, it's Exhibit 5.
Is that the one that is e-filed on 2/2/18?
No, this is a different, it's a one-page document. It's on page 49. It's your Exhibit 5.
I don't know. How does it start out?
Notice of recording, foreign judgment.
And it looks like this is just that one page, Mr. Rich?
Yes.
I'm sorry, but I don't. It's not the.
Which document are you looking at?
I'm looking at the document that is filing 674-12530.
Sorry, Your Honor, one moment here.
Okay.
I'm sorry, because then what I have after what we already talked about is the Bank of America stuff.
And just to let you know, so this is Exhibit 5. This one comes much later. It's almost toward the end of the exhibits. Do you have
Is
those
it
exhibits on your screen?
order to show cause?
Show cause. One moment here.
I have a Collier County return service. Notice of recording foreign judgment. Is that it? I have the certified mail receipts. And then I have notice of recording foreign judgment.
That's it.
Yes, yeah, that's the one.
Okay, yeah, I have that.
Okay. If you could please, if you could describe what that document is entitled again, one more time for the record.
Notice of recording foreign judgment.
What is the date on that below?
January 20th, 2017.
Okay. In Your Honor, I'd ask the court to take judicial notice of that recording of the foreign judgment.
Any objection?
No, Your Honor.
Okay. Exhibit
Okay.
1 and Exhibit 5 have both been offered and admitted by defense.
Thank you. So you had just testified that it was August 29, 2016 of that Tennessee judgment. Were you employed on August 29, 2016?
I'm going to say no with a caveat because I just here and there part-time. I book travel for people and do tours, but I was not like employed by anyone full-time at the
And
time.
when were you, oh, sorry, go ahead.
That's all.
And when were you employed prior to then, full-time?
When I worked for Sotheby's, and I left in December of 2015.
Okay, was that before the judgment in Tennessee?
Yes.
Okay. And when did
But
you
it was a transaction from there was the cause of the judgment.
And when did you become employed again, full-time?
October 10th, 2016.
And do you own any property, or sorry, did you own any property in Tennessee at the time of the Tennessee judgment?
No,
Did you live there at the time of the Tennessee judgment?
no.
Okay. Do you recall a lawsuit by Bank of America against you?
Yes.
And if you could turn to Exhibit 2, which is on page 9, Your Honor, and Brantley, of the exhibits. Sherry, please let me know when you have that Bank of America document up.
Oh, I have it. Sorry.
No problem.
I'm
And
sorry.
could you describe what that document is called?
Verified complaint for foreclosure of mortgage and reestablishment of promissory note.
Okay, and what is the date on the top of the document?
March 23rd, 2015.
Okay, and Your Honor, if I could please ask the court to take judicial notice of this document in the court file?
Any objection, Mr. Oki?
Objection.
All right, I'll grant the request to admit Defendant's Exhibit 2.
Your Honor, Ms. Woods, what was that lawsuit about?
It was about missing documents, Bank of America filing for copies of documents that they didn't have in their file that I didn't have either, and no one could find them, so they started foreclosure proceedings on my condo.
Okay, and did that take place in 2015?
Yeah, 2015 and 16.
Okay, how did you obtain ownership to that property?
It wasn't finished up until like November of 2016. I purchased the property originally in 2001, and then with my ex-husband, and then the property was actually quit claimed solely into my name in 2004.
Was that because of the divorce?
No, it was done way before then. We didn't get divorced or separated until 2008.
And how did the foreclosure affect your finances?
Well, terribly, because I had tens of thousands of dollars worth of lawyers' fees to fight the case.
And how did you obtain money to defend that lawsuit?
From my own funds, what little they were. I sold property that I had, as far as like personal property, clothing, jewelry, you name it. I borrowed money from my ex-husband and a couple of friends.
Okay. Now in 2016, had you filed taxes?
No, my taxes were in arrears at the time.
How about 2017?
No, I believe it was 2018 before I filed for 16 and 17.
And in 2016 and 2017, how much were your expenses approximately?
Pushing $10,000 a month.
What did those expenses consist of?
Quarterlies for the condo, storage fees, gas, automobile, food, of course, electricity, phone, cable, etc.
what about attorney's fees?
Yeah, a lot of it was attorney's fees.
Is that from that Bank of America lawsuit or something else?
Yes, the Bank of America lawsuit.
Okay, and did your income cover these expenses at the time?
No.
Okay. Let's see here. Okay, I'd like to show you Exhibit 4, which Your Honor and Mr. Oki, it's page 42 of the exhibits. And 3, that's the Lawrence Murray document.
That's the what?
It's related to Lawrence Murray.
Oh, okay.
And just let me know whenever you have that ready.
I got it out of order a minute ago. Sorry, because of looking for the other thing. Okay, I have it.
Okay, if you could please tell me what the title is of that document.
A final judgment after default.
Okay, and what is the date of that document?
The what?
What is the date of the document on the second page?
February 7th, 2017.
Okay, and what was the nature of lawsuit?
Yeah, he was a friend. I had rented a place too, and then he loaned me $10,000 against prepaid commissions. And then subsequently, he broke an expensive piece of artwork of mine, which was valued at around $5,500. So $5,000 of this was paid, and then the other $5,500 was supposed to be taken care of by him to either replace or pay for the piece of artwork.
Okay, and Your Honor, I would ask the court to take judicial notice of this document in the court file, exhibit number 4.
Any objection?
No, Your Honor.
All right.
Okay, and Ms. Woods, if you could please turn to, one moment here. Exhibit number 3, which is for everyone else, one moment here, page 39.
Is that the Gmail notice of deposition?
Actually, one moment here. I think I had the wrong. Let's see. On the notice of appearance. This one came after the Bank of America lawsuit, right after it. It's one page.
I think I might have gotten that mixed up. Yeah, I have that.
One moment here. The title of that document.
Notice of appearance.
And what is the date on top of there?
At the very top, February 2nd,
Okay.
2018.
Okay. Do you have any trouble paying our law firm when we took over this case?
Yes. I mean, you guys have been good about letting me pay you monthly.
And are you still paying our legal bills?
Yes.
Okay. Now let's talk about the current lawsuit, right, that we're here today for. How did it get resolved?
Through monthly payments per agreement.
And did you fully pay it?
Yes.
Okay. Now, were you trying to avoid or evade payment of the Tennessee judgment?
No.
Okay. When the judgment was brought to Florida from Tennessee, were you trying to avoid or evade payment of the judgment?
No.
Did you have the money to pay the judgment at the time it was brought to Florida?
No.
Okay. And did you transfer any assets to avoid this judgment?
No.
Okay. Now, I would like to discuss some of the issues brought up by Mr. Oki related to the discovery. Do you recall the interrogatories and requests for production in this matter?
No, not really.
How are documents handled by certified mail at your residence?
We have a 24-hour guard in the building, so anything that has to be signed for is brought to him. But packages and things like that, he can sign for, and we have a room that they lock things up in for us. But if it's certified mail, he cannot sign for it. He either has to call us or, to come down and sign for it. I mean, that's basically it, because the guards are not allowed to send people up to the unit without getting in touch, in touch with the owner, via phone or whatever. And so if he called, he either got me or didn't get me and said someone was there to see me, and I wasn't in residence, so he let them know I wasn't there, and so whoever it was left.
Mr. Oki claims you were avoiding receipt of these documents. Is that true?
No.
Did you receive them from your recollection?
Not until later. Not until later. And one thing is that some notices were going to an email address that I don't use. And later, I don't recall how, but I had finally the process server left his phone number, and I called him to meet, and we met in the parking lot of a Walgreens for his request, and I met him there and signed for the documents.
As far as you know, did you eventually respond to the interrogatories and requests for production?
I'm not sure. Oh, well, I think I was out of the country on a trip at the time. I'm not sure. I think I responded, but I'm not sure what you mean exactly.
Well, when I say respond, actually answering their questions for, say, the interrogatories. Do you recall answering them eventually?
I don't really.
Okay.
I probably did. This has been going on so long. I really don't remember.
Okay. Well, Your Honor, I'd ask the court to take judicial notice of the court file. Sorry, this is taking a little longer here.
Okay.
I'm just going to pull up here. I'd ask the court to take judicial notice of it's docket number 42 and 43. It's the date is March 15th, 2018. Response to request for production, notice of service of answered interrogatories.
Okay, tell me the date again.
Yes, so that's March 15th, 2018.
Okay. Notice of compliance with order compelling discovery and response to request to produce, and notice of service of answered interrogatories. Okay.
I didn't know if that was entered into evidence or if Mr. Oki had an objection or not.
I'm sorry. Yeah,
I don't have a problem. That's fine.
okay.
Be happy to stipulate that they responded to the interrogatories at that time.
Very good.
And Ms. Woods, do you recall receiving a notice of deposition in this matter?
Yes.
And were you in Naples at the time?
No, I was actually out of the country doing a tour with some travel. Well, I have my I'm affiliate out at the time. I was affiliated with a travel agency here, Betty McLean Travel, and like I said, I just booked maybe 2 to 4 at the most trips a year through for people I knew or whatever. And I was on one of these tours with these group tours at the time.
Okay. And do you recall sending Mr. Oki an email about the deposition?
I do, because that's when I realized that some of the correspondence had been going to an email address that I didn't use. And I believe it was John Silverfield with your office who brought it to my attention and told me that's where the notices had been going. And so I went in there. I did find a notice from Mr. Oki, and I responded and let him know that I was out of the country.
And if I could refer the court to, it's page 53, and for you, Ms. Woods, it's Exhibit 7. I believe is the document you're referring to. Are you able to pull that up?
Is that the Gmail document?
Yes.
Yeah.
And is that the email you were referring to?
Yes.
Okay. And I'd ask if the court could take judicial notice, or actually if we could just admit that into evidence, that email.
Okay, this is Exhibit 7. Any objection, Mr. Oki?
Just one second, Your Honor. I'm trying to scroll down to that. No, that's fine. No objection.
All right, 7 will be admitted.
And Madam Court Reporter, could I please double check which documents have been admitted into evidence?
I can tell you that. I'll save her the
Thank you.
trouble. We have done defendants 1, 5, 2, 4, 3, and 7. So 1 through 7, except for 6 by my notes.
Okay. Yeah. 6.
And let me just look quickly and I'll double check that. Yeah, 6 has not, 6 is, looks like something we have not yet discussed.
We're almost about to wrap this up here, Your Honor.
Okay,
Patience.
I have a hearing at 3:30, so.
Okay, let me speed this up here.
For the certified mail thing.
Oh yeah, we don't need that. That's okay.
I
And
just started to say, I never worked here
okay,
where this was delivered.
okay. So you're saying the discovery, you never received it at your work?
No, I never worked here. I basically had my license at Premier Plus just to keep it active, but I wasn't, I wasn't active at the time. The market was still down. I wasn't actively working in real estate, but I did have my license there. But it was the downtown office on 12th. And this is addressed to I just now noticed this is addressed to Fontana del Sol Way in North Naples. I've never stepped foot in that office before.
Okay. For that document, Your Honor, it's on page 51, and that one is labeled Exhibit 6. I'd ask for that document to be placed into evidence. I believe it's in the court file anyway.
Okay, any objection?
No, Your Honor.
Okay, that'll be admitted.
Okay. And then lastly here, Ms. Woods, if you could please look at Exhibit 8, which for everyone else, that's on page 55.
Is that the Collier County Sheriff's Office return of service?
Yes. And how do you recall being served with an order to show cause in this matter?
Yes.
And how did the process server find you?
I called him.
You called him to meet him?
Yes.
Okay. And the very last question here, did you ever, when they tried to domesticate the judgment to Florida, do you recall fighting the domestication? If you can answer that.
Yes.
What do you mean by fighting?
Because they filed a judgment in Tennessee when I didn't have any ties to Tennessee, and then they got their judgment paid for, and then I lost the case to have it heard here when the judgment originally originated from a deal that was done through Sotheby's here in Florida. But he won the case there to file it in Tennessee.
Are you talking about before they got the judgment?
Here, before it was sent here, yes.
Okay, and so in Tennessee, but are you saying before the case was over, you fought the venue?
Yes.
Okay, so you're not talking about, okay, so you fought venue of the initial lawsuit, is that what you're saying?
Correct.
Okay. Okay, I have no further questions for Ms. Woods.
Okay.
I did have a final, Ms. Stroke, you may have a question.
Yes,
Okay.
I do have a few questions, if I may.
Go ahead, please.
Thank you, Your Honor. Ms. Woods, you mentioned you were out of the country. What were the dates that you were out of the country?
I have no idea without looking at whatever I sent you. The
Can
date
you
of
offer
that.
a best estimate?
I know I was out of the country the month of May.
Okay. Why didn't you respond to any of the letters we sent you between January and May?
I don't recall receiving any letters.
What was the address that you were residing at for the year of 2017? Would you agree it's 4301 Gulf Shore Boulevard, apartment 700?
No, actually I was residing, I can't think of the street number right now, but it was on Kings Lake Boulevard. I had my unit rented.
Okay, what was going on with 4301 Gulf Shore?
I had it rented.
Okay. Did you still receive mail there?
Yes.
Okay. Now, you mentioned that your doorman cannot sign for certified mail, but you can still receive the notice of an attempt to deliver certified mail at that address on Gulf Shore. Is that correct?
There were no notices left. When whoever came was trying to serve, they left with whatever they brought. until the day that the guy left his card and his number, and I called him. We spoke on the phone 3 or 4 times because we tried to get together a couple of times that didn't work out. He was either in Fort Myers or whatever, and it just happened the day we met. I was in North Naples on an appointment, and he was actually in North Naples as well.
Okay, so to clarify, you're saying that you never received any letters, non-certified, and you never received any notice from a condominium complex of attempts to deliver certified mail at your address on Gulf Shore. Is that correct?
Correct.
Now, you mentioned that you were listed as a real estate agent at Premier Plus Realty, correct?
That's where my license was.
Meaning you were listed as an agent there, correct?
They were holding my license and I was paying them a fee to hold it there.
Okay, so they had your phone number, correct?
They should, yeah.
So if somebody left a message for you relating to your business, they could pass that message on to you, correct?
They could. I mean, the issue is that I never did any business through them, ever. I didn't do one single transaction through them.
Okay.
I basically just put my license there to keep it active until I put it someplace else once I left Sotheby's.
All right. Now you referenced an email from my office about a notice of deposition, correct? You entered it as evidence at the hearing today?
Oh, the email where I answered and said that I was gone and I'd be happy to reschedule.
Okay.
Yeah.
That wasn't the only email that you received from my office, is it?
This is the only one that I got that day. I was actually out of the country when I got this. And as I said earlier, it's because John Silverfield told me that's where the notices were going, because he said, they've sent you several things. And I said, I haven't gotten anything. The actual email address that I use for real estate is sellingnaples@gmail. This iCloud account, I've never used it. So I don't even know how anybody got it. And it's not even on my server to get emails from. So when John told me that's where the notices have been going, I had to pull it up on my server. And that was the first time when I sent this email to you to say I was gone and I could reschedule. That was the first time I pulled up any of the messages.
Okay. No, but you received subsequent emails from me to that email address, correct?
I guess, I don't know. I don't have them, but that's the first day that I saw any emails.
All right. I'm going to share my screen. Can you see this, Ms. Woods?
Yes.
Okay, can you see, it says here, Naples FL Real Estate at iCloud.com. That's the same email address as the email that you admitted into evidence, correct?
Correct, which is once I put it on my server after April, when John Silverfield told me to check the emails from there, then I did. That email right there on the screen is after this email that I sent April 27th, after talking to John.
You would agree that the date of this email is June 7th, 2017, correct?
Mm-hmm. Correct.
Okay. And in this email, I would state to you that I responded and said that you should be back in town by now, and I attached all the necessary documents and asked you to sign and accept service. You didn't respond to this email, did you?
I have no idea.
Okay.
I would think that John would have.
And there's no reason that you wouldn't have received that email to the same email address that you previously responded from, correct?
I would say that's correct. Again, I would say that I would think that John responded to that email.
Is it your understanding that John Silverfield represented you in June 2017?
Yes.
Okay. No further questions, Your Honor.
Okay. Any other redirect, Mr. Rich?
Sure. Just to clarify, so I know we're very, very limited on time. I wanted to just give a final wrap up of her testimony, but Ms. Woods, could you be confused on just the date that John Silverfield took over? If we can go back just to Exhibit 3, page 39. It was that notice of appearance.
Page 39. Isn't that in the middle of the Bank of America stuff? Oh,
Well,
the notice
actually,
of appearance. Notice of
for you-
appearance, yeah. John Silverfield got it.
Okay. So after reviewing that document, could you have been just confused on the date of the, when he took over?
Maybe.
Okay.
Yeah, I don't know.
Make sure, your testimony is clear. That's all I had for her. If I could give a final wrap up, Your Honor, if you'd allow it.
Okay.
So essentially the issue is, was Ms. Woods avoiding or evading payment of the judgment? Through her testimony, I believe we've shown that she didn't have the ability to pay it at the time and meet her other financial obligations. Whether there was some delays on discovery, maybe she didn't receive it, I don't believe that's relevant to was she avoiding or evading payment. I've shown that she was struggling with this Bank of America foreclosure. Her expenses exceeded her income. And ultimately, she agreed to a payment plan and did pay off the judgment. Some of these other cases cited, there was extensive litigation. In this case, looking at the court docket, all we're simply talking about is one set of interrogatories, one request for production, and one which were both answered, and then one notice of deposition. This isn't a case of her moving assets or fraudulent transfers. Again, limited discovery. And even though she was out of the country, she did communicate with opposing counsel by email to coordinate her depot. She even voluntarily met a process server at Walgreens. These aren't really the signs of someone avoiding a judgment. And again, maybe some deadlines were missed, but she has explanations for that. Essentially, our big argument is that these fees should not be justified under the circumstances.
Okay. Mr. Oki?
Your Honor, just to briefly sum up, I don't think it's believable that Ms. Woods did not receive any notice at the address that she owned. As I testified, we made multiple mailings, not just by certified mail, but by regular mail. None of those were responded to. She testified she was out of the country maybe for the month of May. That leaves January through April with no response. And then after she was allegedly back in June, and we attempted to email her at the same email address, she did not respond to that email either. We left, as I testified, I left multiple voicemails at her place of business. She acknowledged that she had her license at Premier Plus Realty. None of those voicemails were returned. And I would further point out that even after receiving notice of the hearing for the motion to compel, we didn't get any discovery. And likewise with the motion for order to show cause. So she was out of the country for 1 month, but we're talking about a period of January to December where emails are being left, phone calls are being made, things are being mailed to her home, both certified and regular mail. And the only response that was received is that email saying that she was out of the country for that period. So I would submit to the court that well, and let me back up and address the other point. It's irrelevant whether or not she was able to pay the judgment at the time. She needed to receive the documents, or the court documents, allow my client to engage in discovery. She didn't do that. That's why we're here, is because of the work that had to be done to get that discovery and to proceed to determine whether or not we could collect on the judgment. She can't, so it doesn't matter whether she believed that she didn't have the money to pay it at the time. What's important is that she refused to receive any of the court filings, the court paperwork, and to allow us the ability to engage in discovery. So I would ask that the court make a finding that Ms. Woods contributed to the need for the work, the attorney's fees that were incurred, and the work that had to be done to obtain this discovery, and that the court award entitlement to fees and reserve to determine a reasonable amount of future hearing. Thank you, Your Honor.
Okay, Mr. Rich, anything else?
Yeah, the only thing I would say is I really do disagree with just the last part of what he said. The basis of the fees are whether she's avoiding or evading the payment of the judgment. So I believe her ability to pay is directly relevant. And as far as missing discovery, I mean, let's take it to let's just assume maybe she was afraid of a deposition. This is just a hypothetical. Let's say she doesn't show up for deposition. Well, that doesn't mean you're just automatically entitled to fees. It's, are you avoiding or evading the payment? That's the rule. And that's what I try to address today. Thank you.
Okay. Well, I appreciate both sides have done an excellent job of trying to get the information that the court has needed here to assess the situation. And it is something that is fairly unique. I will note that a quick review of the clerk's records confirmed what I believed I recall, which is I had multiple lawsuits with Ms. Woods as the defendant around this area, and that it was a similar experience for each of those plaintiffs to secure service with them. One that, believe it or not, I have a lot of cases, but I remember Ms. Woods on Gulf Shore Boulevard, because you know what I don't have a whole lot of is debtors on Gulf Shore Boulevard. But the process server had to be quite creative, because she verified her car was right there in the lot. And there was a guard 24 hours a day. Also don't have a lot of people in my court who have a doorman, basically. But and Mr. Oakey may even recall, because he was in ex parte trying to get relief early on. I think it might have just been more time to serve. But anyway, Ms. Woods was the subject of an awful lot of paperwork in my office on multiple collections. One was a rent-a-car company. They ended up having to serve her through the state, I guess, for keeping a rent-a-car. So it's something, unfortunately, the court has an independent recollection of these matters. And in what's been rehashed today, I note things like, I understand that maybe you rent your unit and you're not staying there, but you get your mail there. Your testimony is you're both a realtor and a travel agent. Those are careers that your stock in trade is being reachable by your clients. You said this was a bad email and that you had to go in once your attorney alerted you. You had to go in order to see all of Mr. Oakey's emails. And yet, I note that email is an original email. It's not a reply. So instead of just replying to one of what should have been several Oakey emails, there's a fresh email started. There's no suggestion that this is a bad email or use this email instead. It's, I'm out of the country. I also, by the way, don't have a lot of debtors that are in and out of the country a whole bunch on travel trips. So this is something where really the totality of the circumstances makes clear that I do have someone who simply does not want to be served with this, troubled with this, and saddled with this. And I think that this is, going back to my earlier ruling, precisely why 57115 is on the books, is, a judgment's been entered against you, and it's not my business to determine whether that was a good judgment or a bad one, but it's been entered. And if you make them pay all kinds of money to find you, then that ultimately gets put on your tab. And that's really how I read 57115. And the obstructionism, the failure to cooperate, ultimately is to the detriment of the debtor. And if there was a judgment against you in Tennessee and you were aware of it, by the way, and nobody does this, I get it, but the Tennessee court should have been advised of your good address at all times. And if it changed, it should have been updated. And if they couldn't find you after that, again, your rights, your interests were involved. Your decision not to make yourself accessible makes this more expensive. And it is not Mr. Wharton's problem, ultimately. And I think that's what 57115 says. I think that there was somewhere between active maneuvering or just passive negligence and ignoring notices that were coming. But I think that the plaintiff should be reimbursed their fees for that, for having to over and over reach in and try to get what legal process had already determined was appropriate for Ms. Wood. So I'm going to find that plaintiff is entitled to the fees. We'll have to figure out the amount at a subsequent hearing if that's not agreeable between the parties. But unfortunately, this is one that the court remembers, even though it's years ago. It's been going on for years. And it's one of a number of cases with Ms. Woods that I had, and they all had the same problem. So
I get what you're saying, Judge. I just have to disagree on part of it, because I don't know how much mail you get, but I don't even check my mail because everything I have is paid online. So that being said,
Sure.
it doesn't negate anything, but it's just like, unless somebody shows up at 7 a.m. or at 7 p.m., you can't expect somebody to just be at their house.
Yeah, but I can expect them to get mail 24/7, and you should open your mail, because there's still a lot of important legal notices that get done old school. So, if you choose not to be particularly on top of your emails or your mails, that's okay. That's up to you. It's just that there may be a cost associated with that. And if this is an email that someone has for professional reasons and you're not using it anymore, it might behoove you to aim that email and forward it to the one you do use, so you don't miss things that are important. But it's how you choose to do business. It's just that unfortunately, this is a cost. And what I have to determine is, should Mr. Wharton bear that cost, or should you? You don't do much with your mail? Okay, that's fine, but it's an expensive decision. So I find Mr. Wharton's entitled to recover the fees that he spent in trying to get to this point. The garnishment, as we've noted, is segregated out, but we'll have to decide what the amount is. I've had for about 20 minutes my 3:30 people in the waiting room, so I need to really let them in. I would ask Mr. Oakey to just do an order that does reflect my ruling and finding that he's entitled, and then reserves jurisdiction to determine the amount. Is there anything else that we need to address right now, Mr. Oakey?
No, that's it, Your Honor.
Mr. Rich, I know you and Ms. Woods may disagree, but anything else that we have to address on the record before I end the hearing?
No, Your Honor.
Okay, I will look forward to an order once Mr. Rich reviews it for form. If you want to forward that to my assistant in Word format, and you can copy Mr. Rich, we'll get that addressed and hopefully get the parties on their way with this.
Thank you, Your Honor.
Good luck, everyone.
Thank you.
Okay, good afternoon, everybody. Give Give me just one moment. Thank you for your patience. What would that have been? A 2 o'clock hearing that ran long. Let me just get these notes separated out. So I just have my notes. I'm looking at 3:30 for a hearing on Perkins versus Williams and Brothers.
Hey, what's going on with them?
Have I got counsel for Perkins present?
Yes, Your Honor. Gary Green.
Okay, and counsel for the defense?
Yes, Your Honor, Tom Rinaldi for the defendants.
Is that a 6x9?
Okay. And that's my last defendant is still on, so we just muted her. Okay. Mr. Rinaldi, let me just make sure because I haven't switched files yet. Do you represent both defendants in this case?
Yes, Your Honor, I represent both of the defendants in this matter.
Okay, give me just 1 second to get that file up and close the others. Okay. All right, and this is a final hearing on detainer, as I recall. I don't know, Mr. Rinaldi, if you and Mr. Green have had any conversation or attempted to, or if we just need to proceed with the hearing. What's the defendant's intention here?
Yes, Your Honor. I have had conversations with Mr. Green about this matter to bring it to the court's attention, and I'm not sure if Mr. Green is aware of this or not. Claudia Williams and Dwayne Brothers have vacated the premises. The last of the belongings, it's my understanding, we can confirm, have been removed as of, I believe it was noon today. There are a couple of large items that needed to be moved from the premises, and that was complete. That was complete after an application was accepted for a new leasehold. So the issue of possession of the property is no longer at issue. However, there may be other issues for the court to decide today, depending on what the plaintiff's intentions are.
Okay, Mr. Green, were you aware of any of that late breaking news?
I was not, Your Honor. I did catch wind that they may have been in the process of vacating the property, but that's good to know that they are officially have removed themselves.
And is your client on the Zoom? I've got one square labeled Claudia Williams with no video, another one iPhone, and another one Galaxy Tab. Any of those your client, Mr. Green?
I believe Mr. Perkins is on video.
Okay. In a white shirt or a black shirt?
I'm not sure, Your Honor.
You can't see him. Do the gallery view, you'll be able to see everybody.
Yeah, I've never met Mr. Perkins,
Okay.
so I wouldn't recognize him, Your Honor.
Mr. Perkins, you want to wave or give me a thumbs up or something? Okay, he's in the black shirt. And then I'm going to assume then I've got Ms. Williams has labeled herself with her hand up, and Galaxy Tab is probably Mr. Brothers. Okay, good. All right. Now we're cooking with gas, as my law professor would say. All right. Well, then, Mr. Green, I don't know if Mr. Perkins is able to confirm. Mr. Perkins, have you gone to the property or confirmed that it is now vacated by Ms. Williams and Mr. Brothers? You're on mute.
No, ma'am, I did not know they were done yet.
Okay. Mr. Green, this is a complaint for a detainer, so I think it's just for possession. How do you want to proceed in light of what's been suggested? And of course, I can confirm it with sworn testimony if we want to do that.
Well, I'd at least like to get a judgment so that we can be sure that it's clear that they are no longer allowed on the property. We also do have a claim for damages, and I would say that the court should probably reserve jurisdiction on that because we may or may not pursue it.
Okay. Mr. Rinaldi, what's your position on Mr. Green's request there?
Your Honor, we would object to the entry of any type of judgment in this matter for the primary reason that an unlawful detainer action wasn't the appropriate recourse in the first place, that this would be an action under Florida statute chapter 83 rather than 82, because there was a lease in place. If we went through testimony, evidence, and argument, that would be brought to the court's attention. So a judgment would not be appropriate under the pleadings that have been filed with the court and of what's at issue here, for not only because of the substantive arguments, but just the practicality of the situation. If a judgment is entered, that can have negative effects on my clients. And when they look for alternative living arrangements in the future, that could have negative effects. And so we would object to a judgment being entered in that regard. And then also that opening up the door to some sort of damages or other relief under Florida statute chapter 82, that would be inappropriate. So we would object for those reasons.
Okay, well, we can do a couple different things. I'm happy to proceed and take the testimony and hear this. The question of possession may be moot.
My only concern, Judge, is I don't want to run the risk of there being some sort of ambiguity in them coming back on the property and not having some sort of official word from you that
right,
that's not permitted.
Well, so, and we're on the same stream of thought. What I was thinking, what I was curious is whether it would be palatable to both sides to basically enter an agreement that would avoid the judgment, but would give the plaintiff immediate relief if there's any problem with them having vacated, etc. Now, if you do wish to pursue damages, I really have a one count complaint, so it makes it.
It's included in there, Judge, in paragraph 7.
Right, but it's a complaint for detainer. So, oftentimes I have a count for possession and a count for damages. It is in there. I'm just trying to figure out, I don't want to sneak up on anybody as to whether I'm keeping that open or closing that. But I'd like to, if there's a way that's going to be attractive to Mr. Perkins, I already know it's likely to be attractive to the defendants, to basically give Mr. Perkins some assurance that they're out, and if they're not out, he can get his judgment. But if they are out, that perhaps the case goes away, because, or we can have the full hearing, and it may be that theoretically, it could be that I find Chapter 83 was the way to go here, and then Mr. Perkins is potentially paying Mr. Rinaldi's fees, if I recall correctly, but I might be saying that wrong. I can't recall if detainer brings fees or not.
No, it does not, Your Honor.
So neither of you is on the hook at the moment at risk of having to pay the other side's fees if it stays as a detainer. So I guess the only risk then to plaintiff is just the possibility of having a suit dismissed and having to refile if he wants to.
May I ask Mr. Perkins, Your Honor?
Yeah, I was going to say, if you would like, I did this earlier. I can, if it's helpful, I could put Mr. Rinaldi in a room with his clients, Mr. Green in a room with his. Give you all a few minutes to speak privately with your clients, and then I can put you together in a room without me breathing down your neck, and you could talk to each other privately. Is that helpful? Or do you just want to go into a room with each other and you don't need privacy with your client?
Well, may I inquire of my client, Your Honor?
Sure, if you want to do that without privacy, that's always fine too.
Well, I'm just going to inquire as to what his preference would be with regard to that issue. Mr. Perkins, is that something you and I should discuss privately, or are you ready to communicate whether you would be willing to waive a claim for damages in order to get this done today?
Yes, I would.
Oops, that was a compound question, Mr. Green.
I apologize. Are you saying you're willing to let go of the claim for damages, sir?
Yes.
Okay. I know
Sure, I
that-
do.
Okay. If Mr. Perkins then, having indicated he does not care to pursue the damages, Mr. Green, I don't know if that leaves us the
I think that
opportunity.
puts us in the wheelhouse of where you were contemplating that we could put something in place that indicated, that possession was returned,
So what I could
whether it be an
do,
agreement or whatever.
yeah, what I have been doing just to save the lawyers some paperwork is if Mr. Perkins has confirmed, as he has, that he does not need to pursue damages, then what we could do is we could fix a deadline is observed, which it appears that it may already have been, that then the case would be dismissed and each side bears their own fees. If the deadline is violated, if in fact, Mr. Green, it's all, they're still in there and they're still occupying, then you could have a judgment based on their failure to abide by their agreement. Does that sound roughly attractive, Mr. Green? Okay. Mr. Rinaldi, what do you think?
Yes, I think that would be the proper recourse because that would be a judgment based on a breach of the stipulations made in the court minutes.
Right.
And so that would be more agreeable than a judgment based on this specific action that has been brought, if that makes sense, Your Honor.
I think so. It really, if we do the agreement, then any technical deficiencies on either side would be forgiven and the agreement supersedes and just says, we don't care who was right or wrong, but we promise to be out by this deadline. And what I would do is dismiss the case, but reserve jurisdiction to enforce the agreement. And then I think I can get everybody on their way, but it just gives Mr. Green and his client the assurance that there's no surprises and they've still got access to this case if it turns out that, Ms. Williams and Mr. Brothers are still trying to get in or come back. You all are in court with a judge now, so I think you're able to appreciate the gravity of this. Out will mean out for good forever and ever, right? You're okay with that, sir and ma'am? Okay, good. So if we want to fix a date that's comfortable for everyone, then I'll be happy to do. I've got kind of a standard order that I've been doing, and I can minimize any more expenditure of time by the lawyers. Mr. Green, you want to propose a deadline for everybody just to confirm that it's all good?
I don't know, a week or
Where we are.
Monday? I don't know. Whatever Your Honor thinks is reasonable.
Okay. Mr. Rinaldi, what do you think is reasonable on your end?
I believe 7 days is more than ample time for Mr. Perkins to go out to the premises to ensure that everything's been vacated appropriately and for my clients to ensure that something was not left behind for some weird reason.
And so we could say like 5 o'clock Monday, February 15th. And that'll be the deadline all set in my order. And should there be any problem, then the next morning, Mr. Green and his client could file an affidavit that the order's been violated and get a judgment if they wish. But again, I don't want to jinx it, but I have had pretty good success with these, especially when I've had the luxury of counsel on both sides. Everybody's been pretty appreciative of just having that certainty, and everybody's minded their business just fine in these agreements. So if that's okay, the only other thing I'm wondering, is there any keys or garage openers or any of those sorts of things that have to be returned? Mr. Brothers is shaking his head, Ms. Williams shaking her head, so it sounds like it's pretty clean break then. We just want to make sure if there's anything like that, gate openers, keys, mailbox keys, whatever there might be, that all of that is returned prior to the deadline. I would suggest if you have any of those items, get them to your lawyer and he can get them to Mr. Green before the end of this week, so we don't even push next Monday's deadline. Mr. Green, anything else that you would ask that we incorporate or address before I let y'all go?
I don't think so, Your Honor.
Mr. Rinaldi, anything else for the defense?
Not from our end. If you don't mind, I'd just like to get a thumbs up from my clients just to ensure that there's not something else that they would like addressed, or if they would like us to break into a separate room to ensure that It seems like they're both shaking heads no, that nothing else needs to be addressed, but I just want to ensure that.
You guys all set?
Yeah, this is much different than being in person, Your Honor.
I know. Ms. Williams wants to speak. I'm going to ask her to unmute. Go ahead, ma'am.
I would ask that he has a couple personal items of mine still remaining in his house, and I would like them returned to me.
Okay. All right. Well, why don't we do this? Why don't you let Mr. Rinaldi know what that is? Mr. Rinaldi can speak to Mr. Green and see if they can coordinate that. Hopefully that doesn't prove terribly controversial, but if there's some items, it sounded like there was at one time a closer relationship here, and I know it's stressful for both sides, but perhaps the lawyers can
For some of us, we care.
I understand. So perhaps the lawyers can facilitate a handoff on that. And if that proves controversial, it's really a separate issue. But, you know, if we can trouble you guys to help with that, that'd be great. And I'll take care of the order on the agreement.
Yes, Your Honor.
Okay. All right. If there's nothing else, I'll let everybody get going. Good luck to both sides. I know it's difficult times, but hopefully everybody can get through this well. And thank you both sides for your professionalism today.
Thank you, Judge.
Thank you, Judge.
Good luck, everybody.
Have a nice day.
You too. That'll conclude our afternoon.